By 2026, the UK could see one of the largest deportation waves in its modern history, affecting not just undocumented migrants, but long-term residents, workers, and even families who've called Britain home for years. New immigration reforms are rewriting the rules of who gets to stay and who must leave. What's shocking is how easily someone can fall into the danger zone without realizing it. So before it's too late, here's what you need to know, and if you're truly safe. Number 10. Unverified immigration status. As the UK tightens its immigration infrastructure ahead of 2026, one of the most critical issues lies in unverified or outdated immigration status. Thousands of long-term residents live legally, but lack recent documentation to prove it, some due to misplaced papers, others because their records were never digitized. The government's new residency verification initiative will require all residents to confirm their legal status through an integrated digital identity system. Those unable to provide accurate, updated information could be automatically flagged for investigation. The Home Office has already begun reviewing historical files, identifying individuals with unclear immigration histories or missing data links. Officials argue that this cleanup ensures transparency and fairness. Yet legal observers warn it could lead to wrongful deportations if legitimate residents cannot produce decades-old evidence. People who arrived as children or through family migration routes are particularly vulnerable, as their records often remain incomplete or lost. The verification process will rely heavily on data matching between multiple departments, including HMRC, the NHS, and the Department for Work and Pensions. This cross-checking system is meant to confirm continuous residence and lawful employment. However, data mismatches such as name variations, outdated addresses, or gaps in employment records could create false red flags. Lawyers caution that even small inconsistencies might be misinterpreted as evidence of illegal stay. Many residents from Commonwealth nations still face difficulties proving their right to remain despite decades in the UK. Echoing past administrative scandals, human rights advocates argue that the new reforms risk amplifying these injustices unless safeguards and accessible appeals processes are established. Experts recommend individuals secure copies of all immigration documents, including visas, biometric cards, and correspondence with the Home Office. Updating records through official portals and seeking legal confirmation of status could prevent future complications. Advocacy groups are urging the government to provide free legal assistance for those at risk of wrongful classification. As the digital verification deadline approaches, unverified status will no longer be a minor administrative issue. It may determine whether someone continues their life in the UK or faces forced removal. Awareness, documentation, and legal preparedness will become the ultimate shield against this silent but far-reaching policy shift. Number 9. Post-Brexit residency gaps. The aftermath of Brexit continues to reshape the UK's immigration environment, and by 2026, many European nationals could face unexpected threats to their legal status. After leaving the European Union, the UK introduced the EU Settlement Scheme, EUSS, to secure the rights of EU, EEA, and Swiss citizens living in the country. However, thousands either missed the original deadlines, failed to upgrade from pre-settled to settled status, or lacked sufficient proof of continuous residence. The upcoming immigration reforms aim to close these gaps permanently by cross-referencing residency records, employment data, and tax submissions. Individuals whose digital footprints fail to match Home Office records could face status reviews or potential deportation. Officials insist the purpose is to ensure compliance, yet critics fear the move could replicate the Windrush-era errors, where legal residents were wrongfully targeted due to incomplete data. Under the revised system, pre-settled status holders will be required to demonstrate continuous residence and financial activity to transition successfully to full settled status. Automated checks will identify those who have not updated their details, left the UK for extended periods, or failed to meet work and income thresholds. For many, especially retirees or part-time workers, meeting these benchmarks could be difficult. Legal experts note that confusion over documentation remains widespread. Some individuals mistakenly believe their pre-settled status guarantees permanent rights, when in reality it only lasts 5 years. With the 2026 reforms expected to automate enforcement, anyone who misses the transition deadline risks losing legal protection overnight. The Home Office has already begun issuing reminders, yet advocacy groups report that many still remain unaware or unable to navigate the complex online system. Human rights organizations and EU representative bodies have urged the government to adopt a grace period for vulnerable groups, but policy drafts suggest stricter enforcement instead. Migrant support charities warn that the system's digital dependence could unfairly penalize those with limited internet access or language barriers. Experts encourage affected individuals to verify their immigration status online, update records, and maintain proof of residence. As 2026 nears, data precision and timely updates will determine who keeps their residency and who risks removal under this evolving post-Brexit framework. Number 8. Stricter visa renewal rules. By 2026, the UK government aims to redefine how visa renewals are processed, introducing tougher eligibility checks and shorter grace periods for compliance. This policy shift is designed to ensure that only individuals who actively contribute to the economy or meet specific residency criteria can remain in the country. The Home Office plans to reduce tolerance for delays, meaning that overstaying even by a few days could trigger automatic penalties or deportation notices. Applicants will be expected to provide comprehensive proof of employment, income, and accommodation, verified through linked government databases. Visa renewals that once took weeks could now require months of background verification, increasing the likelihood of inadvertent status gaps. Officials argue that this tightening will prevent misuse of the visa system, but critics warn that it may place genuine residents at risk due to bureaucratic backlog or technical errors in the digital application process. One major concern involves the growing role of automation in decision-making. Algorithms will be used to assess renewal eligibility, comparing income records, tax filings, and biometric data for consistency. While this system promises efficiency, even small discrepancies such as mismatched addresses or payroll errors could result in rejections. Employers may also be subjected to more rigorous compliance checks, as failure to verify their employees' immigration status could lead to penalties. Immigration specialists caution that students, freelancers, and self-employed workers could face particular difficulties proving stable income under these new rules. These tighter controls form part of a broader strategy to curb overstays and reduce net migration figures, aligning with long-standing political goals of limiting foreign worker dependency. Experts recommend early renewal applications, ideally 6 months before expiration, to allow time for document verification and appeal if needed. Applicants should maintain updated tax records, payslips, and tenancy agreements, as missing documents will no longer be tolerated under the stricter system. Human rights groups emphasize that the new framework could heighten anxiety among migrant communities, many of whom already struggle with complex paperwork. As 2026 approaches, visa renewal is evolving from a routine process into a high-stakes evaluation, where precision, timing, and transparency determine who can legally remain in the UK. Number 7. Criminal record checks. Under the upcoming 2026 immigration enforcement strategy, individuals with any form of criminal record could face far stricter consequences, including deportation or visa revocation. The policy builds on the Nationality and Borders Act, 2022, which already allows deportation of foreign nationals convicted of crimes in the UK. The new framework expands this principle, potentially applying it even to minor offences such as driving violations, small fines, or public disorder charges. Authorities argue that this approach strengthens national security and upholds public safety. However, human rights advocates warn that it risks creating a two-tier justice system, where migrants face double punishment first through the courts, then through removal from the country. The Home Office is reportedly developing a digital risk assessment model that automatically flags individuals with police or court records for review, regardless of the severity of their offences. This expanded enforcement will rely heavily on data sharing between police, immigration services, and local councils. Once someone appears in criminal databases, their immigration file will be cross-referenced automatically. Even those on temporary visas could see renewal applications denied based on minor infractions. Legal experts highlight that this policy may disproportionately impact young people and low-income migrants, who are more likely to receive fines or cautions. The government maintains that deportations will target repeat offenders or those posing a security threat, yet leaked policy drafts suggest a far broader scope. Some lawyers fear the inclusion of character-based assessments, where behavior, online activity, or social media records could influence immigration decisions. Critics argue that this system undermines the principle of rehabilitation by equating all offenses with threats to national security. Community leaders have voiced concern that it could discourage migrants from reporting crimes or cooperating with police out of fear of deportation. Experts advise anyone with prior convictions to seek legal review of their immigration status before the reforms take effect. Maintaining transparent records and ensuring legal representation could help prevent wrongful deportation. As the 2026 policy approaches, the line between public safety and punitive exclusion appears increasingly blurred, raising deep ethical and legal concerns. Number 6. Fake or invalid sponsorships. The UK's sponsorship-based visa system is undergoing major restructuring, and by 2026, the Home Office intends to tighten enforcement around employer and educational sponsorships. Individuals relying on sponsor licenses, whether through companies, universities, or training institutions, will face heightened scrutiny. Any discovery of fake, expired, or invalid sponsorship could result in immediate visa cancellation and deportation proceedings. The new policy will integrate sponsorship records into a central verification system, automatically tracking the legitimacy of every sponsor. This digital overhaul is designed to prevent fraud. Yet it also means that a single administrative lapse by an employer could jeopardize an employee's legal status. Reports indicate that hundreds of small businesses may lose sponsorship rights due to failing compliance audits, leaving sponsored workers vulnerable to deportation without fault of their own. Employers will be legally obligated to report absences, contract terminations, and job changes within strict deadlines. If a worker leaves employment or transfers roles without Home Office approval, the system may flag them for removal. Universities will face similar requirements for monitoring student attendance and academic engagement. This strict accountability aims to eliminate ghost sponsors who issue work or study invitations without maintaining oversight. However, immigration lawyers warn that genuine migrants could become collateral damage when sponsors neglect their administrative duties. Many employees may not even realize their sponsorship has been revoked until enforcement letters arrive. With technology linking sponsors to migrants' digital IDs, failing compliance checks could instantly trigger immigration action. Advocates argue that, while combating fraud is essential, collective punishment of legitimate migrants reflects an imbalance in accountability. Workers and students who have followed all rules risk losing their residency because of errors committed by sponsors. Experts recommend that visa holders regularly verify their sponsorship status through official portals and retain written confirmation of continued employment or enrollment. As the 2026 system expands, personal vigilance will be critical. Those dependent on sponsorships must stay informed, document every update, and maintain open communication with employers to avoid sudden deportation under these stricter enforcement laws. Number 5. Policy shift on refugee protections. The United Kingdom is entering a new era of asylum and refugee management, and the 2026 immigration reforms could drastically redefine who qualifies for protection. The proposed shift aims to narrow the legal definition of a refugee, focusing on applicants arriving through officially sanctioned routes rather than irregular crossings or third-party countries. Under the new rules, individuals entering through the English Channel or from designated safe origin nations may see their claims automatically rejected without a full asylum hearing. The Home Office argues that this measure will deter illegal migration and reduce asylum system backlogs, yet humanitarian organizations warn that it risks breaching international obligations under the 1951 Refugee Convention, as many fleeing conflict or persecution do not have access to official resettlement routes. Analysts estimate that tens of thousands could be denied protection or face deportation to countries where their safety remains uncertain. The 2026 framework is also expected to expand the inadmissibility category, meaning asylum seekers who pass through another safe country before reaching the UK could be removed without their case being heard. This mirrors aspects of Australia's offshore processing model, where migrants are sent to partner countries while awaiting decisions. Critics argue that such policies will push vulnerable individuals into greater danger, as many refugees lack the documentation or financial means to follow legal pathways. Legal experts highlight that faster deportations might overlook critical evidence of persecution or risk. Reports indicate the government is negotiating bilateral return agreements to expedite removals, suggesting that thousands could be transferred to third nations within weeks of arrival. Charities and advocacy groups call this policy a moral regression, stating that it undermines Britain's long-standing reputation for humanitarian support. They emphasize that asylum seekers often escape life-threatening conditions and deserve a fair process rather than automatic rejection. Communities and volunteers supporting refugees fear that the reforms could criminalize compassion and deter people from offering help. For those seeking refuge, documentation, timing, and legal representation will become decisive factors. As the UK tightens refugee protections, the difference between safety and deportation could soon depend entirely on administrative classification. Number 4. Marriage and relationship scrutiny. Under the evolving immigration landscape, spouse and partner visas are facing heightened examination. The UK government plans to intensify investigations into marriages suspected of being arranged solely for immigration benefits. Immigration officers are expected to receive expanded powers by 2026, allowing them to conduct more frequent interviews, background checks, and even home visits to verify the authenticity of relationships. Couples may be asked to provide deeper evidence, such as shared finances, communication records, and proof of cohabitation, to demonstrate genuine connection. Authorities argue this scrutiny is necessary to curb abuse of the visa system, yet many families fear it will unfairly target legitimate marriages that simply fail to meet bureaucratic expectations. Lawyers predict that a wave of spouse visa rejections could arise from minor discrepancies in documents or inconsistent personal details during interviews. The tightening of marriage regulations comes amid rising political focus on family migration. Officials believe stricter controls could reduce dependency-based immigration and ensure that only genuine relationships lead to permanent settlement. However, critics say the policy risks splitting families, especially in cases where cultural or financial factors make traditional documentation difficult to provide. People from low-income backgrounds, or those in cross-border marriages, may struggle to gather evidence deemed satisfactory under the new rules. Analysts warn that even minor mismatches in testimonies could be interpreted as deception. Recent reports indicate that immigration officers will receive behavioral analysis training to detect alleged falsehoods during interviews, adding psychological pressure on applicants. Human rights groups describe this approach as intrusive and emotionally taxing. They argue that love and cultural diversity cannot be measured through paperwork or interrogation. Many genuine couples could face emotional distress, prolonged separations, or forced removals due to bureaucratic misunderstandings. Experts recommend preparing comprehensive documentation, joint bank statements, utility bills, and photographic timelines to prevent disputes about legitimacy. As the 2026 reforms expand government oversight, marriage-based immigration is evolving into one of the most closely monitored pathways. For thousands of mixed nationality couples, proving authenticity is no longer a personal matter. It has become a legal survival requirement. Number 3. Overstayed student or work visas. One of the most common yet overlooked reasons for deportation in the UK is visa overstaying, particularly among former students and temporary workers. Thousands enter legally through universities, sponsorships, or short-term work schemes but fail to renew or extend their status before expiry. Under the 2026 immigration framework, overstaying will trigger automatic detection through advanced data integration between universities, employers, and the Home Office. When a visa lapses, the individual's record may be flagged for immediate action, leading to detention or deportation orders. The policy aims to close gaps that previously allowed individuals to remain undetected by exploiting administrative delays or data mismatches. With technology linking visa expiration dates to digital identity profiles, the system will no longer rely solely on manual enforcement, making it much harder for overstayers to remain unnoticed. Universities and companies holding sponsorship licenses will face stricter reporting duties, meaning they must immediately notify the Home Office if a student drops out, changes courses, or leaves employment early. This digital chain of accountability is designed to ensure real-time updates on a migrant's legal status. However, critics argue it could unfairly punish people dealing with administrative errors or genuine delays in paperwork processing. Some cases involve individuals unaware that their visa renewal applications were rejected due to missing documents or payment issues. Under the new system, such minor lapses might automatically trigger investigation notices, leaving little room for appeal before deportation orders are issued. Analysts warn that tens of thousands of international graduates and short-term workers could face removal if their records are not updated before 2026. Experts advise anyone on a temporary visa to start verifying their immigration status well in advance, keeping digital and printed copies of correspondence, renewal confirmations, and proof of employment can be vital. Legal experts also recommend setting personal reminders months before visa expiry to avoid unintentional overstays. As the UK tightens post-Brexit immigration control, overstaying is no longer seen as a minor infraction. It is treated as a direct violation that may result in permanent re-entry bans and immediate deportation. Number 2. National security and border monitoring. The UK is rapidly expanding its national security infrastructure to monitor every movement in and out of the country. Under the upcoming reforms, authorities plan to integrate biometric identification systems, including facial recognition, digital fingerprints, and iris scans across airports, workplaces, and public services. This expansion aims to detect individuals with inconsistent or incomplete immigration records, linking data from various departments such as the Home Office, HMRC, and NHS. The 2026 framework will rely on artificial intelligence to flag potential security risks or residency discrepancies automatically. Officials argue this will strengthen border integrity and prevent identity fraud, but privacy advocates warn it could evolve into a mass surveillance system affecting millions of law-abiding residents. For many migrants, the growing data network could mean constant monitoring of their daily lives. Every flight booking, job change, or public service interaction might feed into the government's central immigration database. Those with unresolved visa issues, unverified travel histories, or expired permits could be automatically flagged for review. Security agencies claim this system will help prevent terrorism, illegal migration, and document fraud. Yet, experts caution that errors in biometric recognition or mismatched personal data could lead to false alerts and unwarranted detentions. Recent reports suggest that data sharing agreements with private employers and landlords could expand, meaning residency verification might soon become a condition for renting homes or starting new jobs. Civil rights groups describe the plan as a potential threat to personal freedom. They argue that embedding security monitoring in daily activities risks creating a climate of fear and mistrust, especially among migrant communities. Critics also question the accuracy and fairness of algorithms used to predict risk or verify identity. With digital borders replacing physical ones, mistakes in system data could have devastating effects on ordinary lives. Experts recommend individuals maintain accurate travel and employment records, as these may become crucial in proving legal residency. As national security policies tighten, awareness and digital transparency could determine who remains safely documented and who becomes vulnerable to removal under the 2026 measures. Number 1. Mass deportation policy under immigration reform 2026. The year 2026 could mark one of the most controversial shifts in UK immigration history. The government is reportedly preparing an Immigration Reform Act that may enable large-scale deportations targeting those who fail to meet new verification or residency requirements. The reform aims to create a centralized digital identity system, linking every resident's immigration status to tax, employment, and health records. Those unable to confirm lawful residence or lacking consistent data across government systems could face immediate investigation and removal orders. Officials argue that this measure is designed to strengthen border control and reduce illegal overstays, yet critics warn it may affect long-term residents who have lived in the UK for decades without updated documentation. Legal analysts highlight that over 2.3 million people could be flagged for reassessment under these upcoming protocols. The reform is being fueled by rising political pressure to reclaim border control following ongoing public debates on asylum backlogs, overstays, and visa abuse. Sources within the Home Office suggest that mass deportations could be justified through newly expanded enforcement powers, giving immigration officers authority to detain and remove individuals without lengthy court processes. The policy is also expected to merge with post-Brexit border agreements, allowing the UK to repatriate individuals to partner nations more efficiently. Analysts believe the 2026 policy could echo the Windrush scandal, where lawful residents were mistakenly deported due to missing papers, yet this time on a much larger scale. Critics from human rights organizations warn that such measures could disproportionately affect ethnic minorities, migrant workers, and asylum seekers. Many worry that automation in data verification might increase wrongful deportations due to technical errors or mismatched information. Advocacy groups are urging residents to regularly update their immigration records, retain copies of official correspondence, and seek legal support if their residency status is uncertain. The government maintains that legitimate residents have nothing to fear. Yet experts emphasize that complex documentation systems often disadvantage vulnerable individuals. As the 2026 reforms approach, awareness and preparation may be the only true safeguards against the sweeping consequences of this policy shift. The upcoming 2026 immigration reforms are shaping up to be one of the most transformative and controversial policy shifts in the UK's modern history. From mass deportation powers to stricter visa renewals, every aspect of immigration control is being redesigned to tighten borders and verify residency. Yet beneath these legal changes lies a deeper concern. Millions who have lived, worked, and contributed to the UK for years could suddenly find themselves questioned or even removed. Whether it's due to missing documents, expired sponsorships, or digital record errors, the new system leaves very little room for mistakes. Experts warn that preparation and awareness will be crucial. Now is the time to check your immigration status, update your records, and seek professional advice if anything appears uncertain. These reforms may be presented as administrative improvements, but their impact will be deeply human. Families, workers, and students who once felt secure could soon be caught in a wave of enforcement they never expected. The difference between safety and deportation may come down to paperwork, timing, or even a small data mismatch. Staying informed could make all the difference. If you found this video helpful, hit the like button, subscribe for more updates on UK immigration laws, and share this video so others can stay aware too. Drop your thoughts or experiences in the comments. Have you or someone you know faced visa or residency challenges? Stay alert, stay informed, and protect your right to remain in the UK.